Welcome back to Heart of Employment, the podcast dedicated exclusively to California employment law and protecting workers just like you. My guest today, he's back, the founder and managing attorney of D.Law, Emil Davtyan. Welcome back.
Thanks for having me back.
You're welcome. And we are, for episode 4, continuing our conversation on class action because it's such a big topic. We felt there was more to say. In last episode, we talked a lot about how for a class action, it's really for a case that may not be big enough for a single worker to bring. So class action allows a collection of workers to come together in order for a case to be brought either to trial or to a settlement. And one thing we didn't get to, which is probably one of the first questions people ask about class action, is how big does a class action even have to be?
The way class actions start is really the will of at least one individual. So you need at least one employee who's been affected by these wage claims. There can be more of them if we have more people, but typically when they contact us, there's only one person who's ready and willing to take the journey with us, with the attorneys, to go through a class action case, and that's the only person we need to jumpstart the case. Now, that person needs to have experienced all the wage-related issues that we would bring as part of the class action case,
Right.
And the case would be on his or her behalf and on behalf of other employees who have experienced similar claims.
So, but how many people are needed in a class action? 10, 20, 30? What is a typical size of a class action, and is there a minimum?
There's really no minimum to start a class action, although companies that have at least 40 to 50 employees, 40 to 50 hourly employees who would be affected by these violations is typically what we look for as attorneys. Just when it gets smaller than that, the company might not be big enough to sustain a class action lawsuit like this.
Okay, so help me understand still. So you get a call, somebody has a violation, and you guys think, okay, this is going to be good for a class action. You're going to what? Contact somehow most, if not all, the members, the employees at that company, and let's say you only hear back from 3 or 5. How does that work? How do you, because the idea is you need enough to kind of make the settlement in the end worth it. So how do you make sure you get enough employees as part of the case?
Good question. This is one of the misconceptions of employees when we tell them about class actions. One of the first things they tell us or ask us is, how many other employees do I need to go find for us to start a class action?
Yeah.
And the short answer to that is we don't need to go find other employees if there are none readily available to talk to us. And really our need to talk to additional employees is to learn more about their experiences that they've themselves had. It doesn't make the class action lawsuit, you don't need more than one person, essentially, right?
Wow.
So you need the one person to start, but knowing more facts, knowing what other employees have experienced, by talking to additional employees if they're available, that can only help the attorneys to craft a better class action lawsuit. But more often than not, the reality is we don't have more than one person who tells us what both his or her experience is personally, as well as what they observe other hourly employees having. And we use that as basis to start the class action. Now, you can start the class action and learn favorable facts, and you can learn unfavorable facts. One of the things that we may learn that may be unfavorable after filing the class action is that our named plaintiff was maybe the only one who was affected this way. Everybody else didn't have the same effect, in which case the class action may not continue as we thought it would be when we were starting the case.
Right. So how do you find out if it happened to 30 people then?
That's part of the lawsuit process. So
Okay.
during a lawsuit, we lawyers engage in discovery. That's what the name is, as one of the early stages of filing the case. You engage in quote unquote discovery. You ask questions to the company's attorneys, and then they get to ask questions about our plaintiff.
Right.
So we learn more facts as the case goes on through this process called discovery, and we sometimes solidify our claims. Sometimes we have to eliminate some of the claims if we find out that the effect may not have been as widespread.
So, and last question on this, but I'm realizing I didn't even know as much about class actions as I thought. So, you bring this class action, you have this main plaintiff, and so let's say there's 50 other people at the company. Let's say the violation did happen to them too. Now, if the whole case goes forward, did they ever have to do anything to get money, whatever the award is at the end? Do they have to do anything, these other employees, to get that money at the end? Are you fighting essentially on behalf of everyone the whole time?
We are effectively fighting on behalf of all employees. In a more typical scenario where you filed a case after a brief period of the case pending, where we agreed to go to what's called a mediation, which is the day that we sit down with a third-party mediator who helps us settle the case. We don't typically end up needing more information from class members, so so they don't get involved in a typical case.
Okay.
But in other situations where where the case advances to a bit more complex processes through the courts, we call that class certification, which is where we have to prove to the court that there's many people affected, there's many violations of different wage and hour laws. In that scenario, we may have to reach out. We're given the contact information by the company and their attorneys of the employees, and we have an obligation to reach out, interview them, and learn more facts and use it. But that would be the only involvement, just for them to share with us their experiences so we can use it to prove a certain type of a claim.
So if, and we'll round out this topic on this question, which is, so if my company's involved in a class action, I don't even know about it, D.Law took care of it, you guys were successful, I may just get a check in the mail one day. Is that correct?
You would first get a letter notifying you. If it just settled without much complication, then it would be a letter notifying you about a settlement.
Oh.
So check wouldn't just out of the blue just get to your mail.
Okay.
You would first get a letter saying, by the way, there was this case. This is what this case was about. So-and-so brought the case, and this is how much money the case settled for, and your estimated amount that you would get from the case. So there's that notification first. And then after that notification, we have to go through a couple of steps with the court to approve that settlement. And after it's fully approved, defendant pays the money, funds the settlement, then you will, months and months later, you will end up receiving that check in the mail.
Great segue, because I was going to ask, what's the average length of a class action? And then if I'm involved in one, what am I getting paid?
When people ask me this during the first consultation they have with our firm, I usually estimate that a typical case takes on average 1 to 2 years.
Long time.
Can it take longer? Absolutely.
Wow.
Can it take shorter than a year? Almost never. That's because class action cases affect a great number of employees, right?
Yep.
And because of that, courts have a role in kind of a watchdog role to make sure that employees of masses get a fair deal. So when there's a settlement, it's not like an individual settlement where there's a private agreement, the terms are confidential, and you sign, and then within 30 days you get the check, it's done. It just doesn't work that way with class actions. And that's because when there's a class action settlement, we have to submit those documents to a judge to go through 2 levels of scrutiny, or a more appropriate term is approval, preliminary approval, and a final approval. We first need to present to judges the terms of the deal, how much it's settled for how many people, what were the strengths and the weaknesses of the claims. And the judge needs to sign off on the deal and say, this is a fair deal that you essentially were able to negotiate on behalf of class members. And in a best case scenario where you filed a lawsuit, within 6 months, you agree to go to mediation, maybe another 6 months later, the mediation happens. So say about a year after filing the case settles at mediation. Then it takes about 8 to 10 months at the very least to go through an approval. So first, maybe 3-4 months later is the preliminary approval, and then another 5 months to the final approval, and then another maybe 2 to 3 months after that to issue the check. So it's a lengthy process, but we lawyers have that role of navigating not only our named plaintiff, but also all the class members, because at the end of the day, we as class action lawyers are the ones who are helping them to recover the money. We're helping them to navigate through the legal processes, legal system to get them the money. They pretty much would have to wait for the right time for them to get the check, but almost all the work in that sense is done by the lawyers.
Once you get that letter that you said that I might get if I'm an employee and the company has settled on a class action, how much time from then do you think that they would typically get the money?
When they first get notified about a class action settlement, that's usually after the judge gives preliminary approval.
Right.
About 8 months.
An additional 8 months.
Additional 8 months, correct.
Okay. Just out of curiosity, I always wonder, so when you get 3 years, now is a lawyer working on that every single day, or is it just kind of like we have to do something and then we have to wait for something to come back or for a judge ruling? Like, how much daily work goes on each one of those days?
Great question. Attorneys don't work on a case that takes 3 years every day.
Right.
It just doesn't work that way. Usually cases start slower because you file a class action lawsuit. It needs to get assigned to a judge. Sometimes it takes a few months for it to get assigned, and also the judge to also set what they call an initial conference, an initial hearing just to talk to the lawyers, to understand what the case is about, what kind of a plan it has going forward. So it starts slow. So first few months, usually not a lot of activity going on. But the discovery stage we were talking about earlier can get heated. That's where maybe the bigger fights happen between attorneys, where we're requesting information and they're objecting to giving us more information. We plaintiffs' attorneys would like to usually get more, and defense attorneys want to give us less. So there's usually fights over amount of information that gets shared in a discovery
stage. Are
these
actual fights? Like, are you yelling at each other over the phone, or is it kind of like, I don't want to do this? And it's like, well, you have to.
Sometimes it can be that you raise your voices, but a lot of times it happens on paper. Just what we call motion practice, where you file certain documents. There's very little in-person interaction, but it's mainly in writing. Through letters, motions, arguments in court, not necessarily
to
directly. Correct.
It's not always like the movies.
Not at all.
Now that fits into a question people almost always have, which is, why do lawyers get so much of this money? We see it on our Facebook and Instagram comments a lot as like, oh, this isn't even worth it. The law firm's going to get 50% of the cut or whatever it is. Can you explain what is the average cut that a law firm gets from a class action, and why is it that amount?
It gets characterized a little worse than you described, which is why do lawyers get all the money?
Right.
And it is a myth that is just incorrect. Lawyers don't get all the money. In fact, lawyers don't get most of the money. Employees for whom we fight in these wage-related class actions collectively get majority of the money than the attorneys. And in a typical case, 25 to 33% of recovery is how lawyers get paid,
Right.
but many times it can be less. When a case settles, we have to submit documents to the judge explaining what exactly we've worked on, how much time we've spent on, and if the judge is convinced that we should not get 25 to 33%, many judges may cut that amount to being less than that. The remaining of the money, as I said, 25 to 33% would be paid to the lawyers. The rest of the money, taking away a few administrative costs, would get distributed to all employees. So it is not true at all that lawyers get all the money or most of the money, because the remaining of the funds needs to be distributed to all the employees who are class members. Now, I can understand why an individual employee might view it like that as a misconception, is when you look at it from your individual point of view. Yes, you as an individual are going to get a lot less than the attorneys, right? But this is not an individual case. This is a collective case as a group on behalf of yourself as well as many others. Them as a group is what we're fighting to get the money, and only 25 to 33% of that goes to the attorneys. The rest gets distributed to class members.
And you're not making any money until that comes up anyway, right? It's because you work on contingency. You're essentially working for free until that payment comes through.
Exactly, and there have been many times where we have done a lot more work in a case than what that 25 to 33% may be. Even worse, where we spend so much time and the case results in small recovery because there is only a small number of employees ultimately affected. And then in more rare situations is that you don't end up recovering anything for one reason or another, including if a company files for bankruptcy, then attorneys don't get paid anything.
Yeah, so there's a risk for everyone.
100%.
Let's switch topics a little bit to the topic of arbitration agreements. You hear this word batted around. I think sometimes people don't quite even understand what they are and how would they affect a class action.
The more common question I get about arbitration agreements is, what is an arbitration agreement?
What is it?
The basics of an arbitration agreement is an arbitration is a private legal system outside of the public courts.
Right.
So the judges that you know of, that's not what arbitration is. Arbitration is a private court where everything is kept confidential. And this is one of the things companies generally prefer, where if you're going to sue them, you don't sue them in a public court. You go to a private arbitration. If an employee has signed an arbitration agreement, one of the things we attorneys have an obligation to do, good attorneys who care about this work well, is to analyze the arbitration agreement to see if it's even valid. Or does it have any ways?
It's not valid.
Sometimes it claims to do things it's not supposed to do.
Okay.
So we attack it and we challenge it. And if we're successful in challenging it, then it has no effect. But if the agreement is good, or we try to perhaps challenge it and it's unsuccessful, then it needs to go to private arbitration. And what that does is it allows us to pursue a different type of a case, not a traditional class action case, but what's called a PAGA case. It stands for Private Attorney General Act, which allows employees to recover certain types of penalties, and it's limited to the last 12 months of the period that our lawsuit covers.
What percentage, I feel like maybe workers are thinking about this, of these arbitration agreements that end up being bad or that are thrown out, is that common or uncommon?
It's a good mix.
It's a good mix. So it's not completely uncommon.
I would say most arbitration agreements tend to be valid because companies have had different tries with these arbitration agreements, and they've improved if they've had good lawyers that they've given them good advice on what these arbitration agreements need to be. but more often than not, they're good, in which case we are limited to only the PAGA type
Yeah.
case, which for all intents and purposes, PAGA case is same as a class action. It's a group case. It has limited ability to, or it has ability to recover more limited damages, so there's maybe less money available, but it's also for a shorter period of
Yeah.
time, which is 12 months from the date that we file the
Right.
lawsuit in court, as opposed to if it's a regular class action, we're usually able to go back up to 4 years.
Okay, got it. As we're running out of time, I'm going to try some quick questions, quick responses here. Severance agreements. I signed one on the way out. Am I screwed? Am I not getting in on this class action lawsuit?
99% of the time, that's what it means,
Okay.
because severance agreements function in a way where the company pays you some money, some extra money that they might not necessarily owe you as final wages, in exchange for you to sign the agreement that contains a general release. General release effectively means that I'm not going to come back and sue you for anything. So class action, individual case, these are all become off the table because you signed your rights away in a severance agreement.
And one quick question on the arbitration. That's for cases that are individual cases, not class action. That's holds up in that case, those cases as well, an arbitration agreement.
Arbitration agreement affects similar way in an individual case.
Okay.
In a sense where instead of going to a public court, you have to go to arbitration.
Yeah.
For an individual case. For class actions, it just allows a different type of a group case instead of a traditional
But
class action.
D.Law and most employment law firms, they're going to handle arbitration cases as well, or no?
Yes, that's correct. Correct.
Okay. And last question as we round out here. Where do these cases go wrong? What do plaintiffs do, people you work with, what do they accidentally do that kind of screws up the case?
One of the common things that do come up more often than we'd like to see is when we settle the class action, it usually settles for a considerable amount of money. Let's say in the hundreds of thousands, sometimes in the millions. Mm-hmm. And the size of these settlements are based on, because it was about on behalf of many employees.
Yeah.
For a long period of time, right? Because the case started with one person typically, and they take a lot of pride in that, and that's important for them to understand that they have a really important role. Sometimes when they see these big numbers, some of them get greedy.
Yeah.
And they present things as, I was the one who started this case. I should get half of that money, right. Or all of that money. Why are now lawyers getting a big chunk, more than I do? Even though we've explained to them all along about these processes, when they see big numbers, their perspective usually changes, and it can become challenging to explain it again and for them to come to terms with that the case was a group case. It was for the benefit of not only yourself, but all the other class members. And that's one of the things that's really important for anyone who wants to do a class action. They cannot put their interest first. They have to put class members collectively, their interests above everything else. And when their interests of getting more money, wanting more money gets in the way, that's a conflict for a class action. And many times we may not be able to conclude a case with that person, and therefore they might not get the bonus or enhancement at the end of the case if they want to take that position that they have to get more money. They're going to get usually more money than an average class members because of the class representative bonus or enhancement that we talked about. Outside of that, the case is a collective case. It's for the benefit of all class members. It's one of the things that they need to be brought back to reality by the lawyers typically, that explains that this was done for the benefit of everyone, not just you.
I think that's a good message to kind of wrap things up here. which is I think people think lawsuit. They see the signs on the buses or the commercials, millions, millions, millions. So everybody thinks whether it's a class action or an individual case, if I sue my employer, I'm going to be a millionaire. And there is such a wide range of different awards that employees get that really, a message I've heard from other lawyers who've talked about is do it for the justice and do it because, yeah, you'll get what you're owed, but how much more than you're owed it's hard to say. You can never guarantee. So don't always get into these lawsuits because you want to be a millionaire. You get into it because you're owed something, you were wrongly treated, and you want justice from the company.
That's correct. And one of the things that I emphasize before they sign our retainer agreement is that if you're expecting a lot of money from this case, this is not the right type of case for you.
Okay.
If you want to become a millionaire after this case, this is not the case that you want to be involved in. We have these discussions every day with the folks who are interested in class actions. But fast forward a year, 2 years later, somehow these conversations get forgotten when they see the big numbers, and we try our best to bring them back to reality.
And that's why we're doing this podcast, to remind people and hopefully inform them. We're out of time. Emil, thanks for round 2, our second appearance. You did great. Thanks for joining us.
This was awesome. Thank you.
This is awesome. And that does it for us for Heart of Employment. Hey, if you got questions, we got answers. Email us at heart@d.law. D.Law is our website, too. You can also hit us up on all of our different social media channels. No D.Law. No, like, you know. And until next time, I'm Dave, and we'll see you at Heart of Employment.